Good afternoon to one and all. Symbiosis Law School Pune welcomes you to the virtual book launch and panel discussion on the book The Global Indians and the Law. It's written by Advocate Anil Malhotra and Advocate Ranjit Malhotra. It is a one of a kind book on international family law jurisprudence dealing with a wide range of issues such as nationality and citizenship, marriage and divorce, child custody, guardianship and adoption, surrogacy in India, past, present, and future, overseas Indians, succession issues, etc. To engage in a panel discussion, we are joined today by an esteemed panel consisting of Honorable Justice Dr. S. Muralidhar, Judge Punjab and Haryana High Court, Advocate Anil Malhotra, author, legal analyst, IAFL Fellow, and alumni of SOAS London. Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, and Dean, Faculty of Law, Symbiosis International Deemed University. Mr. Narinder Singh, Consultant in International Law and former Chairman of the International Law Commission, United Nations. Ms. Reshma Sambari, Attorney and Counselor at Law, State of Michigan and Illinois, USA. The co-author of the book, Advocate Ranjit Malhotra, was unable to join us today. Is an esteemed member of the Bar Council and was the first Indian lawyer to be awarded the prestigious Felix Scholarship to read for the LLM degree at the School of Oriental and African Studies, University of London. To introduce you all to the panelists today, we have in front of us Honorable Justice Dr. S. Muralidhar, Judge Punjab and Haryana High Court. He's he has secured LLM in Constitutional and Administrative Law from Nagpur and secured the first rank in the Bachelor of Laws course from the University of Madras. He's a PhD holder in the University of Delhi in February 2003 for his doctoral thesis entitled Legal Aid in Criminal Justice System of India. He's a judge to High Court of Delhi. He was pronounced with various landmark judgments dealing with a variety of issues, and it is an honor to have him with us today. He's also the recipient of Lakshmi Narsa Reddy and the N.C. Miller Medals and the Carmichael and Innes Prize in 1984. He's a qualified advocate on record examination in 1990, securing the first position in merit and was awarded the Mukesh Goswami Memorial Prize. A very warm welcome to you, sir. Next, we have Advocate Anil Malhotra, author, legal analyst, IAFL Fellow, and alumni of SOAS London. He has secured his LLM from the University of London in comparative family law. He has authored several books, to name a few, Acting for Non-Resident Indian Clients, Indians, NRIs and the Law, Surrogacy in India, A Law in the Making, and so on. He's the chairperson of the Task Force for Policy Procedures Resolution Grievances of NRIs. He's also the additional Central Government Standing Counsel of High Court of Punjab and Haryana. We extend a warm welcome to you, sir. Dr. Shashikala Gurpur is the director of SLS Pune and Dean, Faculty of Law, Symbiosis International University. She secured a PhD in International Law and a gold medalist in her LLM. Dr. Shashikala Gurpur is a member of the Board of Management of SIU. She's the former member of the Law Commission of India and also member of the Academic Council of the National Judicial Academy, Bhopal. She's a part of academic boards of various national law schools and universities and a member of the curriculum development for the Bar Council of India. She's an awardee of Fulbright Scholarship, National Merit Scholar, and National Hindi Scholar. She's also been awarded the Karnataka State Youth Award, AHRB Fellowship to Edinburgh University, and an award for excellence in legal sector, My Equality Award. She's listed in the book 100 Legal Luminaries of India by LexisNexis, and she's also a recipient of Kittur Rani Chennamma Award by the Government of Karnataka in 2018 for contribution towards the empowerment of women. A warm welcome to you, ma'am. We also have on the panel Mr. Narinder Singh, a consultant in international law a former chairman of the International Law Commission of the UN, and an additional secretary, a retired additional secretary for the Ministry of External Affairs, the Legal and Treaties Division. He's the chairman of the UN International Law Commission in 2015. He's a professor emeritus at Maharishi Law School, Maharashtra University, Noida, NCR, Maharishi University. He's also a member of the Eminent Persons Group of the Asian and African Legal Consultative Organization and the Secretary General of the Indian Society for International Law from 2012 to 2015, and a legal advisor to the Permanent Mission of India to the United Nations from 1998 to 2002. He's the recipient of the MC Basuni Justice Award in 2017 and has represented India at a number of bilateral and international negotiations, including the UN Convention on the Law of the Sea, International Criminal Court, Hague Conference on Private International Law, UN Commission on International Trade Law, to name a few. A very warm welcome, sir. We're honored to have you with us today. We also have, all the way from Michigan, USA, joining us, Ms. Reshma Sambari, who's an attorney and counselor at law and a social worker. She's currently pursuing her LLM in human rights at the Symbiosis Law School, Pune. She's the co-founder of JAPE Foundation, a charitable trust that serves the children and women from tribal and rural and underprivileged areas through the provision of economic empowerment skills and sustainable living spaces. She served on the boards of various nonprofit organizations and state-level advisory committees in pro bono capacity. In 2015, she founded a nonprofit called the South Asian Women's Association in Michigan to advocate for the interests of South Asian families and to provide legal, counseling, and other essential services to the victims of domestic violence, sexual assault, LGBTQ hate crimes. We are highly honored to have all the esteemed panelists join us today. And I would now like to invite to moderate the panel discussion, Dr. Shashikala Gurpur.
Good morning, respected Justice S. Muralidhar sir. And today is what we call in Marathi or Hindi Utsav Murti, or star of the show, the author of this book, which is the theme of discussion today, Global Indians and the Law, Advocate Anil Malhotra. The other esteemed panelist, Mr. Narinder Singh, and our own dear attorney Reshma. First of all, I welcome all of you to this panel, and I will take the privilege of introducing the themes and the book. This is not a role which is like any other moderator in a panel discussion. This is more like our territories have a very clear demarcation, and it's a kind of global desi kind of activity, because the theme is Global Indian and the Law, and the venue is desi. One speaker is connecting from another part of the world, from the US. So it's a kind of hybrid kind of situation that we have here. For the benefit of all the panelists who have joined for the first time, who might be knowing about Symbiosis Law School Pune and Symbiosis brand of law schools already, I would like to quickly introduce you to the way in which we use such extension programs as an educational avenue to our students. We call this as extension program in order to enrich students with the experiential learning, which they glean from the experience of eminent panelists that we have today. I don't think I'm anywhere near their experience. Each one of them is very primarily engaged with, is a very strong stakeholder who is primarily engaged with the legal system in a direct kind of confrontation of conflicts, whether it is our Honorable Justice Dr. S. Muralidhar as a walking campaign on human rights, whose life and work all the time reverberate with genuine engagement with human rights, uncompromising in values. Whether it is Advocate Anil Malhotra and his brother Ranjit Malhotra, who are decorating our own eminent visitor faculty status and their work, standing up for the cause of Indians who are lost in the lurch of various legal complications, or whether it is the work of Mr. Narendra Singh.
एकदम चला रहे पापा, पता है मम्मी एकदम उल्टी लग रहा है मेरे को.
Could we please request the audience to, I think it is Smriti Abhilasha, to put your mic on the mute, please. Thank you. Mr. Narendra Singh's own profile is about acting as India's voice in major negotiation tables at the international level. And Ms. Reshma, as the profile was read out now, also stands as a person who stands up for women's rights and human rights in a family law context. So we have very carefully chosen this panel. Of course, the major role was accomplished by Advocate Anil Malhotra. He guided us throughout in planning this whole event. And we also welcome the publisher, the Oakwood publishers, Oak Bridge publishers, who are seen on the pamphlet and whose logo is seen in every slide that you're seeing, audiences, who have helped us in bringing this event together. So I welcome each and every one of you. I put my note of gratitude for accepting our invitation and for being on the panel. I would not like to take too much time here, deviating from our main focus today, the book discussion. Yet I would like to say that in Symbiosis Law School, Pune, which now stands as one of the top 10 law schools in the MHRD's National Institutional Ranking Framework, competing with the top national law schools and well-invested private law schools, still maintaining its lead position as the third best law school in the country, although it's not a university. Also standing up for various accolades earned by its young students, whether it is parliamentary debating, whether it is global debating, whether it is Manfred Lachs, or having honorable mention in Philip Jessup. So we have had such a glorious track record ever since it was founded by our esteemed Chancellor, Dr. S.B. Muzumdar Sir, way back in 1977, that by 2010, the demand for our brand of law school went so high, for 300 seats receiving like 10,000 applications, motivated us to start the Symbiosis Law School Noida. And then we went on to replicate it in Hyderabad in 2014. And by 2014, we were very, very strongly into all-round law learning with much focus on research, as lead universities in the world would do. So we developed the one-year LLM program under the aegis of this consolidated Symbiosis Center for Advanced Legal Research. So what we abbreviate as SCALSER. And then by 2019, we went to Nagpur in central India as part of Maharashtra as well. So this has been our journey as a law school. So we don't see any of those law schools as isolated islands of excellence, but as expanded excellence from Pune. Because all the incubation of ideas happens here, and then it is cascaded across all the law schools. So any student in any law school of Symbiosis is there to gain from such programs. So today's program also has got a lot of my faculty and students from other law schools of the Faculty of Law as well. Because we feel that this is a very, very unique theme, and this has got a very close connection with the DNA of Symbiosis, that is internationalization. And we follow 12 indicators of internationalization, ranging from mobility of faculty and students to content development to developing global skills. So as I welcome you all, I'm very happy to put on record, both the Malhotra brothers have been great contributors in their last 2 years of close engagement and earlier few years of on-off engagement in developing a solid input to the idea of global legal skills. And secondly, Anil's classes are always electrifying kind of experience to students. First of all, his vibrant energy, as you see there. And secondly, his strong communication skills. And thirdly, the themes that they bring to the table, the way in which he brings his experiential nuggets to the class. I mean, it is a kind of delight of any student who is set out to become a litigator or a scholar in law. So as I go forward, let me first of all show you the book, which is there in the background of Anil. Now, why do I show the book? There is a saying that don't judge the book by its cover. I would say judge it by the cover, because the book opens up with these two very important phrases: the global Indians and the law. I've got a little mischief to make here, which I'll make at the end because of the title. But if you look at the spread out map of the globe, you don't see empty globe there. It is filled with people, and Indian people, and with their diversity and their colors, and the way in which they have adapted to what we call as in identity sciences or cultural studies, liminality of identities or hybrid identities. So all that is beautifully reflected in this picture. So we have to judge this book by cover. And then the second important thematic connection that we make is the idea of diaspora. Who will not be looking at this idea of diaspora in a very enthusiastic manner? If you recall Namaste London or Jhumpa Lahiri's path-breaking short stories, one of them made a global hit as well with one of the lead actresses. And then this whole idea of border crossing resulting in a personality transformation, and accompanied by the force or compulsion to adjust to a different legal system, different situation, and laws regulating the life causing new challenges. So just visualize that, all the students. So that's a kind of global Desi experience, global and Desi. And then you come back to India, you don't know whether you are the same person. Do you relate to your same village scenario or city's eating experience in the same way? Or are you finicky about cow dung and cows going around in the street? So this kind of liminality, transgression of identity, and creating one's own hybrid identity are the different possibilities if you look at diaspora studies and the way in which it affects the deeper interior of an individual Indian. However, with the second generation and third generation, the choices become very clear. If they are into the kind of ISKCON and other kinds of cultural communities, they may relate to India by taking a little India there. Anil does reflect that when he discusses law. So I was trying to investigate Anil's mind as an author and Ranjit's mind as co-author. What kind of identity do they transgress or represent when they write this book? And I am going to highlight maybe in the concluding remarks, because I do not want to take away the privilege of our panelists to discuss the content of the book. Now, I would like to say that the inanimate map gets animated by discussing people, discussing cases, discussing their realities, discussing their struggles, conflicts which are across the border. Sometimes, I mean, in one of the chapters, it is very clearly written by authors. Sometimes people simply come to India to sue, especially using or abusing the Dowry Prohibition Act and the dowry violence provision 498A. So these points have been very nicely captured. The colorful author brothers, as I already highlighted the colorful personality of Mr. Anil as well as Ranjit. First of all, these global legal skills, as I told you. Secondly, being heroes in the class with their lucidity of expression. Thirdly, as vibrant teachers and dedicated teachers and very deep scholars. Theoretical as well as black letter law, what we call as black letter law, the legislation and the case law, and the accurate grasp of the issues and words and the way in which it is presented. Now, the book and the concept is very dear to me. It's very dear to my heart because to some extent it mirrors the theme of my own life as a global Desi. But I wouldn't call myself as global, but global Desi, because I would not like to give up my commitment to the millions of years of civilization, the most ancient civilization in the world. And the country which has shaped me as an individual. And then comes the influence of two stalwarts in the field of family law and law in general, or advocacy. One is Verrier Minsky and the other is Soli Sorabji. Who could ever understand the Malhotra writings without the shadows of these two great stalwarts lurking in? It's not only in the way in which the book is organized, the same discipline, the same insight, the same critical stance, and the balance. And on the other hand, the same mischief, the wit. So I will point out at some points it is very glaring. And then the other thing that I thought was a kind of generous way in which they have organized these critical masses in India. What kind of critical mass? Both Malhotra brothers have been instrumental with their public relation and access, and they have spent their personal time and energy in bringing lot many reforms to law. Students, this is a kind of model for you. I always say one's career graph is a model for you on how to lead. Our panelists themselves hold this by example. So we have had, I have been privileged to be in some of the forums which the Malhotra brothers had organized with various embassies getting engaged there, whether it is the issue of surrogacy bill or the issue of cross-border removal of child, or if it is the issue of NRI phenomenon, especially NRI marriages. So my question is, Anil, tell me why this is global. Because your earlier work was international Indians and the law. I don't understand if international Indian promotes himself or herself to be global, or is it just a convenient use of the term, or is it because your son is studying in a global university that you have taken it as a fashionable term? More and more of banking on that. So maybe when your turn comes, you could tell me why. So that's one. Second is, if I mean, as a moderator, I'm doing the role more of a facilitator to understand this book. So if you open the blurb of the book, we have a very interesting laying down of the introduction to the theme, the significance of the theme. Now, what is the significance of the theme? The significance of the theme is that there are 3.4 millions of global Indians cluttering 200 countries of the world. And this figure may be unofficially 30 millions because only those who go in and out of India have been documented. And then they encounter so many issues. And these issues may range from domestic violence to intercountry adoption, to cross-border child removal, to surrogacy, to individual solutions being sought after in the Indian courts or through the intervention of embassies. Some of them come and go as illegal migrants, or they may be seeking citizenship. Some of them may be stateless because of the larger political impact, like the Tibetans. So all these have been beautifully captured and structured in a very disciplined way, weaving a kind of very comprehensive work around these key themes, which are closely bound up. I would differ with the moderator who said that it's a family law study, closely bound up, combining public law, family law, private international law, and the concerns of constitutional law. And as our favorite scholar and judge, Justice Raghuraman, beautifully put it, very useful to all stakeholders. So this book is very useful, and it meets, as he said, let me quote, meets the critical need for a comprehensive book. And in his classic style, Justice Raghuraman is a wizard with words and literary flair. So he says, iridescent beacon of comprehensive, wholesome justice. I mean, he uses all other words like in the wilderness of lack of such work. And then we have another eminent jurist, who Justice Balram Gupta, Professor Balram Gupta. He talks about how this book is addictive, how this book is digestive. And personally, I feel that the personal comparative family law training that both Malhotra brothers received in SOAS and London School of Economics, and their 4 decades of practice, and their application of public law and private law concern, and weaving it around some of the crucial human rights issues that confronts non-resident Indians and global Indians on day-to-day basis is the classic achievement that is made through this book. And this is as another person who has written the foreword said, that this is a reader-friendly book, very well researched, this is divided into 7 parts, as you would see the thick size of the book, but it's very easy to see the scheme of the authors, including issues of citizenship, nationality, surrogacy, matrimonial law, succession, conflict of suit or anti-suit order, conflict of suits, anti-suit order, maintenance, family, marriage, divorce, and the important FAQs and legal dimensions on OCI, NRI, and PIO. We all use these terms interchangeably, but it is very precisely laid out with the relevant legal provisions. And also the most controversial recent development in the fag end of 2019, the CAA issue, Citizenship Amendment Act. The other classic contribution of the book is the statelessness being discussed with the help of case laws of this Tenzin case of the Tibetan refugee, among others. And the most important pressing issue in the modern days, where some of our Pune lawyers also have raised an issue on execution of foreign judgment or recognition of foreign law and foreign judgment. Of course, the authors have nicely weaved it around the Narasimha Rao case and Section 13 of CPC, and have brought in many judgments, including the unpublished case laws, and they have also dealt with the issue of wills. So I bring my little presentation in the beginning as a moderator just to open up these issues. I'm sure that each of the panelists will take up each of the areas, and they will do their reflection as the important stakeholders in India and abroad, and representing the Indian stakeholders abroad as well. And some of our students would raise the question. And before opening it for the students for discussion and the audience in general for discussion, I would make my closing remarks, where I will have a few more difficult questions for Anil, asking him, tell me why. So before that, I also welcome all our esteemed audience, which may include some of the friends of the Institute and friends of the Malhotras, and the great fans of all our eminent panelists, especially fans of Justice Muralidhar, I'm sure. So over to the moderator to invite the panelists for their presentation. Thank you one and all, and welcome once again.
Thank you, ma'am, for that introduction and giving us insights into the book that we are now going to discuss in detail extensively. So I would first invite Honorable Justice Dr. S. Muralidhar, Judge of Punjab and Haryana High Court, to deliver his comments.
Very warm good afternoon to all the panelists and to the larger audience of students. And I'm particularly thankful to Dr. Sashikala Gurpur and Mr. Anil Malhotra for asking me to be part of this panel discussing this remarkable book, Global Indians in the Law. I'm presuming that I have 15 minutes to make my comments, and we are beginning now. I think it's 12:30, so I believe I can go on till 12:45.
I can give you 10 minutes of mine, don't worry, sir.
No.
They will be well listened to.
Yeah, so in the time allotted to me, I wish to highlight 2 or 3 issues affecting global Indians. And I'd like to add at this stage a question that I think was touched upon by Dr. Gurpur herself. This expression global Indians, I find, does not has not been actually defined by the authors in the book. And this book, again, would like to add to what Dr. Gurpur says. This book, in the words of Justice Raghuram, has been a beacon of light for those groping in the dark wilderness of intersecting legal regimes and jurisdictions in the area of personal relationship conflicts. Indeed, the heart of this book, and which speaks for the vast experience of the authors as practitioners in this particular area, is in chapters 13, 14, and 15, concerning enforcement in India of foreign decrees in family and matrimonial matters, and the laws in relation to child custody, guardianship, and child removal in India. I thought that was the core of this book, as I could see it. The authors make a forceful plea for carrying forward the suggestion made by the Supreme Court of India 16 years ago in the Nirja Saraf case, that a law should be enacted to prohibit annulment by a foreign court of a marriage between a non-resident Indian, NRI, and an Indian woman, and make executable abroad the decrees of Indian courts for maintenance and alimony by entering into reciprocal arrangements under Section 44 capital A of the CPC. And that suggestion still remains to be implemented. It's more than 16 years now. Authors also take a definite position on India requiring to sign on the Hague Convention on the issue of child custody and child removal, which came into force nearly 3 decades ago on 1st December 1983. The Hague Convention, they point out, has 100 contracting nations. And the authors forcefully argue that under the present dispensation, in the absence of principles enshrined in the Hague Convention, Indian courts determine the child's best interest, whereby any child removal is dealt with like a child custody dispute. To quote their comment, in this process, the litigation is a fight of superior rights of parties. And the real issue of the welfare of the child becomes subservient. And they go on to comment, the overpowering parent aims to establish his and I suppose her rights, and the resultant determination of the best interest of the child is a misnomer and a misconception. Such a settlement is not in the best interest of the removed child, a close quote. The authors argue that it is the court of the country where the child had his or her home before the wrongful removal or retention that took place, which will have to decide this question. But as the book itself reveals, this is a highly contested issue, and we've had several moves, including at least 2 reports from the Law Commission of India, and very recently a multi-member committee which submitted a 2-volume report in April 2018. And if I'm not mistaken, Mr. Anil Mehrotra was part of it. And they proposed a draft bill titled The Protection of Children, Inter-Country Removal and Retention Bill 2018. Among the various proposals that this bill puts forth is that abduction of the child by a parent should not be termed as kidnapping and should not be made the subject matter of penal law. We are bound to have more debates on this issue when and even after the bill becomes law. I turn to a specific issue raised in the book at pages 11.28 and 11.29 in the context of entitlement of a wife to public funding in India in pursuing her litigation. The authors are skeptical that the Legal Services Authorities Act 1987 may not be able to provide an Indian wife in distress abroad the full range of legal services, and that the only benefit that the wife in a given case might probably get is the access to a lawyer who can file and fight the case for her, the divorce case for her in India, without any fee for his services or without court fee. They also comment, and perhaps with some justification, that, and I quote here, the quality, speed, and efficiency of such service, professional service, cannot be guaranteed at all. That then brings me to an important issue, which I think requires to be addressed urgently. And this is not an issue that is touched upon in the book at all. The need for legal advice, counseling, and services of not just Indian women stranded abroad or facing issues of domestic violence, but a whole range of global Indians who reside abroad and who find themselves helpless and sometimes in situations of extreme depravity and affront to dignity. I specifically have in mind instances that have emerged in the recent past of Indian labor force languishing in the Gulf countries in the wake of the COVID-19 lockdown in those countries and forced retrenchment of such workers. Such workers have not been paid their salaries for months on end, and with no means of recovering those dues or even returning to the country. In fact, we've had the government of India organizing special flights to evacuate some of these workers. But they're in a dilemma. If they leave the country, the hope of recovering the dues is completely lost. And they're really left in the lurch. And here we are speaking not just of documented, skilled or semi-skilled workers with immigration check required, that is the ECR, stamped on their passports. In a 2018 report prepared by the International Labour Organization, ILO, on Indian labor migration, it is noted that there are over 30 million and we're talking of 3 crores, over 3 crores of Indians overseas, and nearly 9 million, which is 90 lakh of the Indian diaspora, concentrated in the Gulf Cooperation Council states, the Middle East states. It notes that over 90% of Indian migrant workers, most of whom are low or semi-skilled workers, work in the Gulf and Southeast Asia. Data, unfortunately, is available only for those workers migrating on an ECR passport and to only one of those 8 countries which the government of India permits for such ECR stamping. However, several studies have pointed out to the presence of larger outflows of undocumented migrants on non-ECR passports and to all non-ECR countries. And there's no data available on this. There has been a study done, I think, by the same ILO, International Labour Organization, which reveals that since 2015, there has been a steady drop in the number of such documented migrant workers leaving India to those 18 ECR countries. And there's a proportional increase of migration from other countries, and particularly they refer to Pakistan and Bangladesh, into the GCC countries. Now this decline in the official migration of labor from India is attributed to the drop in the crude oil prices and to the overall economic slowdown in the GCC countries. But what it also means is that those non-documented workers that are in large numbers there have a very uncertain future. They don't know where they stand. Many of them have to give up as security for their own employment their passports and very valuable documents to the employer. He almost retains it as a bargaining power. And many of the heartbreaking stories that have appeared in the national and international media show the plight of these workers, packed like sardines into small living quarters. And many of them are construction labor. And the quarters are, like shanties with no facilities. And they also face physical abuse. And about 1/4 of our migrant workforce are women. And we've had stories of women being abused, physically abused by many of these workers. So a serious question arises, what kind of legal services can be provided to this large body of Indian migrant labor, not just in the GCC countries or Southeast Asian countries, but world over? In fact, when I started looking into this issue, I found a 2009 report prepared by the United Nations Organization Office on Drugs and Crime, the UNODC. They'd done a joint study with the Indian Social Institute way back in 2009. And that is titled Smuggling of Migrants from India to Europe and particularly to the United Kingdom. And this was done specifically in the context of Punjab and Haryana. They were able to find out that there are 4 districts in Punjab, which is Kapurthala, Jalandhar, Nawashahar, and Hoshiarpur, from which you have a clear, trend of increased illegal migration. Earlier, it used to be from the families of Jat Sikhs and Lubana Sikhs, but they find that now there are other communities also in these 4 districts who are migrating in large numbers. This is a 2009 report. It talks of more than 20,000 youths from these districts every year attempting illegal migration. And they say the trend has now spread to Haryana, to Himachal, to Jammu and Kashmir, to UP. And when they went to those villages and talked to the persons there, they did not consider it to be a stigma that the migration was illegal and that you may go in undocumented fashion. And you could actually be on the wrong side of the law in those countries. This is a very telling comment in that report. It says the social structure, which was traditionally based on caste, landholding, family background, and educational achievements, has now changed. And it distinguishes between families that have persons who live abroad and those that don't. So this has become the new kind of a status symbol. And therefore, there's an unrelenting push of illegal migration from India abroad. And if you want to probe deeper into this issue, it is very telling that nearly 90% of the labor workforce in India is in the unorganized sector. And with no certainty of employment, and with increasing rates of unemployment, and with no guarantee of even minimum wages, people are willing to undertake great risks and sell off whatever land they have, the properties they have. And the going rate, and this is a 2009 study again, the going rate for paying agents, and these agents are again a very young group of between the ages of 25 and 35. Families are having to pay as much as 20 lakh to 30 lakh rupees if you want to migrate to US and Canada. Somewhere between 9 and 12 lakh rupees to migrate to the United Kingdom. Anywhere between 6 and 12 lakhs to migrate to any of the European countries, which are in great demand. And these are all documented studies where people admit to having paid these amounts and admit that they were first taken to some African country. It could be Mauritania, Guinea, Mali, any of those West Saharan African countries. And from there, taken by a boat or locked into a container and then taken across the seas to Spain, the Spanish authorities stopping you, deporting you. And this is a constant pattern that has emerged. Despite these deportations, people still want to take that risk because there will be one son or one relative who has made it past all barriers, who has found useful employment or has even managed to get permanent residency or maybe even citizenship. So this is a constant lure, this lure of what bright future exists outside Indian shores that continues to draw a large number of Indians out of the Indian borders to other countries. So there is this whole Indian labor workforce that is being exploited, that doesn't have remedies, is stranded on shores abroad without proper papers, facing the risk of deportation, facing bans of not being able to enter any of those countries again, resorting to all kinds of illegal measures. And is there a way, and I do know that there have been efforts made by the government of India to sensitize people about the issue. They've brought out pamphlets, they've tried to document how this whole system works. But I think from the point of legal services, the National Legal Services Authority, in collaboration perhaps and consultation with the Ministry of External Affairs, needs to come out with something concrete and suggest measures of providing immediate legal assistance or advice. It could be even by a panel of lawyers who are at one end of a telephone line or who are able to provide counseling and advice to such persons who find themselves stranded abroad. And since a large part of this audience also consists students, I would urge you to watch 2 films on the plight of illegal migrants abroad. And you can easily imagine this could be any Indian. One film is called Crash. I don't know how many of you have seen it. It is a 2004 film. And the other film is called Babel. And you know what the plight of an illegal migrant in the United States is through these 2 films. It is a must watch, and I wish you had the screening in any of your clubs or meetings that you have in your colleges and universities, where you can have a discussion around the film and probably also invite some distinguished speaker like Mr. Anil Malhotra, Mr. Ranjit Malhotra, or Mr. Narendra Singh or Reshma, and they can give you additional insights into what Indians abroad, what plight they find themselves in. So this is apart from that whole group of Indian women who face domestic violence in the US, who are again deprived of their passports, their documents, simply thrown out of the marital home and have to fend for themselves. Sometimes many of them are stuck, not even being able to return to India because they don't have the money for it. So, and there are only so many consular offices in the different states in the US or in other countries. And there's a limitation on the kind of services a consular office can provide. And when the documentation is incomplete, the consular offices are really hard pressed to be able to trace out, the origins, the families in India, and to provide effective services. But here I'm actually focusing on legal services. And in conclusion, I want to focus on one more community of Indians, which is abroad, which is again not spoken of in the book. And of course, one book can't cover all these issues. But since this discussion today is on global Indians, I thought I should flag it for a discussion. And I'm sure Mr. Malhotra will find the time and resources to address these communities of Indians abroad as well. The community of Indian students. It was an eye-opener to me as a result of the COVID lockdown and issues that cropped up, that there are a large number of students from Jammu and Kashmir who are pursuing an MBBS course in Kyrgyzstan. I don't know how many of you are aware of this. They have been stuck in Kyrgyzstan. They've been thrown out of their hostels in Kyrgyzstan because those have become the COVID recovery centers. And they're again left in the lurch. So they've been trying to reach out to the embassy and to the authorities here, and many of them are unable to fly back to India because they want to complete their course. So I'm just taking this as an example. Apparently, the Central Asian republics, and we are talking of Turkmenistan, Kyrgyzstan, Uzbekistan, that the whole of the Central Asian republics, there are a large number of Indian students there. There are Indian students in China. So students who've gone abroad to pursue higher education, first of all, they don't know if this is a sensible thing to do, but they're taking their chance. Their parents are obviously prepared to part with large amounts of money for this bright future that they see for the child who's able to pursue a degree abroad. And many of you must have known that the Homeland Security Department in the US actually, as a decoy operation, in 2015 and again in 2019, set up a fake university. It's called the Farmington University Farmington University in Detroit. And persons who overstayed their visa enrolled the students here in the hope that this might somehow permit them or legitimize their overstay in the US. And as many as 200 Indian students were arrested by the Homeland Security Department. And there have been, heart-rending situations. And I've seen pictures which are available on the net of students wearing, anklet monitors and having to pay large sums of money just to be able to return to India. So there's also an exploitation of students. And this has been commented upon adversely by some leading personalities in the US. But I would again like to, flag this as an issue where students also need legal advice. They need legal assistance, and it's at a very early stage in their careers. They should not have to face exploitation of this nature. So the two large communities that I spoke of, the Indian migrant labor force, the Indian students, I think that requires a whole set of discussions. But I'm essentially responding to the comment that is made in the book on the quality of legal services that can be provided. I think it's a justified comment that we don't know about the quality, but I think there is much work to be done in that area. I think the area should be legal advice, counseling, and of course, litigating in Indian courts. And this can't be confined to any one section of this large population of global Indians abroad. So with that, I'm sure I've exceeded my time limit. I commend the authors for bringing out this book and for generating all this discussion. And I would urge the student community to think over some of the issues that I've flagged. And these could be points for research and further development of the law, because much needs to be done in the law for these undocumented global Indians. Thank you.
Thank you, Honorable Justice Dr. Muralidhar, for your expert comments and insights. You've highlighted the plight of Indian diaspora across the world, especially the exploitation of migrant workers, illegal migrants, and now we are newly discussing the plight of Indian students and the impact of this on the country's economy and international response or lack thereof. Thank you. Thank you for that discussion.
Sorry, can I just add one factor, which again the ILO report brings out? The remittances made by Indian migrants into India. Those remittances are far higher than even the FDI inflows. So there is a contribution made by these illegal migrants abroad to the economy of India. So this is not an issue we can afford to ignore at all, even from an economic standpoint, not just a pure humanitarian standpoint, because they do contribute very directly to the economy of India. So this is an issue that does require very urgent attention.
That's right. Thank you, sir. Thank you so much for your comments and insights into this topic. I would now like to invite our next panelist, Advocate Anil Malhotra, to express his valuable opinions on the discussion at hand today. Welcome, sir.
Thank you. At the outset, I wish to thank Dr. Gurpur and Justice Muralidhar for their sharp, provoking insights and very meaningful and very purposeful comments on what is these issues which need to be deliberated upon and which maybe don't find a part of the book. Now, my first address to the common issue is, why global Indian? Why is this phrase not defined? What is the issue at stake? Now, I academically and professionally see that our population of non-resident Indians has grown phenomenally, and they have proliferated and migrated to so many countries. But our laws have failed to catch up with their identity as also with their problems. You will be very surprised that the definition of the non-resident Indian is actually in the Income Tax Act. If he spends 182 days outside India, he's a non-resident Indian. If he doesn't, he's an Indian. So this is the kind of classification we have given. We have gone into a dual citizenship phenomenon by recognizing an overseas citizen of India. But have we tried to define who is a person residing abroad? Have we ever gone into the concept of a global Indian? Now, I have, in a very exponential way or in a very analytical way, expressed him to be a global Indian, because even they say when Neil Armstrong went on the moon, the first thing he was an Indian who came and shook hands with him. So where is the Indian? The Indian is everywhere. So therefore the Indian is a global Indian, and therefore the Indian is a non-resident Indian, an overseas citizen of India, or a person of Indian origin. We keep using these terms, though interchangeably, without any meaning. The second issue which we need to flag is, we made laws in the 50s and the 60s. People have brought in new concepts of marriage, divorce, surrogacy, adoption, abduction, maintenance, succession, inheritance. But sadly, our statutes have remained where they are. So it is left to the wisdom of honorable judges like Justice Muralidhar to cull out on a case-to-case basis whether it is a man from South Africa or a man's German national sitting in Dubai, whose cases I have dealt with and I've argued before him, to find out a solution on what to do. Because statutory law is grey. So our judiciary, be it mirror orders in child abduction, be it sending children out born through surrogacy by giving them exit permits, or be it in inter-country adoptions by giving them NOC through CARA, in Hindu adoptions, again a grey area. So what is happening? It's a confused jurisprudence. Now, we have talked about all this in the book. I come to focus exclusively on the area which Justice Muralidhar focused. I may share with my lords that I have been associated with the government of Punjab for the past 10 years in enacting and implementing what is called the Punjab Human Smuggling Act 2012. Now, this act was enacted by the government of Punjab to regulate agents who indulged in the business of sending people abroad by the nomenclature of agents. This act is now called the Punjab Travel Professionals Regulations Act. It has been challenged twice. I assisted the previous government as a pro bono counsel for 5 years in defending this legislation. Now, in Punjab, we tried to address this problem because the Indian Immigration Act of 1983, which is the principal legislation governing outbound immigration, fails to address the issue of this nature. Now, the problem in North India is human smuggling. Human smuggling is going abroad by consent by paying XYZ sum of money. So what did Punjab do? Now, since Punjab could not legislate on a central subject, so they enacted on a subject which is part of the concurrent list to say that anybody indulging in the business of sending people outside the country, be it for education, be it for employment, be it for any other recreational purpose, that agent should be registered with the government of Punjab. Now, all the agents in the Punjab, Haryana and Chandigarh belt started calling themselves as consultants. So they said, we are consultants, therefore we are not amenable to this act. And when they are sought to be registered under the Indian Immigration Act, they say we are not doing the purpose, we are not fulfilling the obligation of sending people abroad on employment. So what is happening? There is an unregulated regime of people sending people abroad through illegal means, and there is no law to check them. So I think what we need more importantly on an all India basis is a human smuggling enactment. I have been associated with the UNODC also for a large amount of time. As president of the chairman of the task force on NRI issues, I have authored 5 reports with the government to see how we can build the infrastructure through the help of foreign missions, the British High Commission, the Canadian Consulate, the Italian Embassy. The visa facilitation services was created to help people to decide on filling up forms, not going to agents, and going through official channels. But in this whole infrastructure, the support and the build-up of the government of India is missing. I am one with Justice Muralidhar on the issue that we need to build an infrastructure in India, and we need to build an infrastructure in the consular section of all the embassies abroad to help 2 most vulnerable categories of persons who are affected by this regime. 1, the illegal migrants, and 2, now the students, and 3, stranded spouses, be it men or be it women. Now, if we are able to set up a network within every state to guide people on what to go abroad for, how to go abroad for, and maybe have an official department of the government to regulate entry for employment or education through that process, we may be able to check dubious institutions and dubious employers. The second limb of the argument is that in the embassies abroad in every country, we have a consular section who is supposed to assist Indian passport holders. But the sorry state of affairs and the sad part of the factor is, I am one with it because I see people coming to us for legal help, that these consular sections actually do not really substantially offer the help which they are supposed to provide. I remember the instance of assisting my court as an amicus when there were about 300 boys stranded in Iraq picking up ammunition from the fields. There was no way we could bring them back. So through the assistance of the court, I was asked to give means. The embassy was asked to generate funds, collect all the boys, give them emergency travel documents, and we brought the boys back, and Justice M.M. Kumar, as chairperson of the Chandigarh Judicial Academy, took them in as trainees, and we trained them as brand ambassadors to carry the message after giving them 1 week's program, and they were actually able to prevent a lot of people. But sir, in North India, I want to go abroad. I don't know where, I don't know why, I don't know for what. I just want to go. Because the man next door has an aeroplane-shaped water tank on his car. When he comes, he goes in a new car. So the lure of money takes people abroad. So I think the embassies did their part in creating visa facilitation services. They did their part in asking the government to do effective things. But the regulatory law in India and the mechanism abroad to check all this is missing. I have done plenty of work in this. Obviously, it could not be made a part of this book because that is the entire jurisprudence in itself. But sir, human smuggling is a big area which needs to be addressed globally. In our court, we daily find applications by agents wanting to be let free. But then the judges say, what are you doing? Why should we let you go? You are the ones who took the people the wrong way. You are responsible. But they wash their hands off. Why? Because there is no regulatory law. What do you punish a man for? You have sent him illegally. The transactions are all in cash. There's no evidence. There's no proof. You paid 20 lakhs. You get 2 lakhs back. You say, all right, matter settled, compromise, end of story. So this is a gray area which perhaps needs to evolve. But what is more important is legislation in areas of family law, legislation in areas of children. We seriously need to have a child abduction law in place. As back as 1 week ago, a bench of the Supreme Court has given a judgment asking for the return of children to the US, affirming Justice Satyanarayana's judgment with some modifications. How long can we go on with piecemeal patchwork? I argued a matter for 3 years with 6 litigations, and I argued before the court, let us have a mirror order jurisprudence. The Delhi High Court order was mirrored by a court in Connecticut. And the reassurances put in place by the Delhi High Court were made a part of the US court. It was affirmed by the Supreme Court. So till we have a law in place, maybe this works. My issue is, if we can have a regime of inter-country adoptions, the JJ Act, the adoption regulations, CARA in place, why cannot we have it for child abduction? And more important, why cannot we have it for surrogacy? We have brought in a surrogacy bill of 2020. We are allowing surrogacy to infertile Indian couples with 5 years of marriage. We are allowing widows, we are allowing divorcees, but we have taken out all foreigners, we have taken out all OCIs, all PIOs. Now, if you are allowing adoptions to single persons, irrespective of marital status, why cannot you allow surrogacy to people of foreign nationality? Why not people of same-sex relationships? Now, these are issues which our laws don't answer. And they ultimately come to courts and create what is known as crisis situations. Now, similar issues come up when we talk of domestic violence, when we talk of marriages. Our law of maintenance is as gray as it is, 1/3, half. Should we pay by the foreign country's source of income? What parameters should be laid down? How will we execute a foreign court judgment on matrimonial issues? Now, the problem is 30 million people have gone. Some are OCI, some are not. They're in 200 countries. You marry in India, but you divorce abroad because it is very quick to get a divorce. But then what happens to your divorce on irretrievable breakdown? It's no good. Rupak Rathi versus Anicha Chaudhary, a brilliant judgment in which I assisted Justice Ryan as an amicus. We studied Narasimha Rao and Nirja Saraf, and we said this is it. But then, where is the statute? Should courts decide to fill in the lacunas over and over and over again? I would most humbly say no. The Indian Society of International Law, I remember being associated with late Ram Nivas Mirdaji, who was a pioneer in the private international law regime. Studies were generated. A lot of work was done. Law Commission's reports evolved issues, but the answer in the statutes, sadly, is missing. And I am, for the benefit of Justice Muralidhar and all others, circulating 2 videos on illegal immigration. There is one PowerPoint which I made, and there is another video which a Kerala-based group made, which looks at the problems very analytically, and it goes countrywide in looking at the issues and saying what should be done. With these words, I don't want to speak more. I leave it for the other panelists to delve more. Thank you.
Thank you, Advocate Anil Malhotra, for your insights as an author of this book, a legal scholar and a practicing advocate. Your extensive research and expertise on the topic is evident. You've discussed the issue of human smuggling and the legislative lacuna that exists, and the practical problems of immigrants and the need for regulating foreign entry and protecting Indians. Thank you very much for your views, sir. I would now like to call upon Mr. Navinder Singh to express your opinions based on your rich experience and expertise on the topic under discussion today. Welcome, sir.
Thank you for giving me the floor. Firstly, I would like to thank Professor Gurpur and Mr. Malhotra for inviting me to be a part of this very important program on release of the book of Global Indians and the Law. I also had the pleasure of listening to Justice Muralidhar and the issues which he highlighted. Now, the issues of private international law, especially where they concern NRIs, is a very important one. The number of Indians who have migrated and are living abroad for work, for those who go abroad to study and for other purposes, is increasing year by year. Various figures have been mentioned, but the important point is that the increase is quite large. And with the increased numbers of people who are living abroad, there are also a number of legal issues which arise. Firstly, when people move from one country to another, they are moving into a different legal system. They have rules which are different from those they have been accustomed to from childhood, and they have grown up knowing those rules, understanding those rules, and suddenly now they are in a different system. And sometimes the rules of these two countries, that is the country of their origin and the country where they have now chosen to live, to work or study, those rules themselves may not be aligned with each other. And that is where this whole issue of conflict of laws comes up. Sometimes the differences may be only on procedure, but very often you can also have substantive differences. Justice Muralidhar highlighted this issue of illegal immigration from India. People wanting to travel at any cost to leave their country and to go and settle abroad, thinking that this would give them a much better life, and in the belief that the streets there are going to be paved with gold and it is just there for their picking. That, unfortunately, once they land there, they find this is not the case. And then you find them doing all kinds of menial jobs just to keep body and soul together. Sometimes these persons, they approach our embassies abroad for help, and the embassies repatriate them at government cost to India. In fact, for many years, we have had serious audit objections, because when a person is repatriated, he signs a bond that he will refund the money to Government of India. But we are aware that in most of these cases, before going, he has sold off all his property, just handed all this money to an agent to somehow take him to the land of opportunity where he hopes to make a fortune. So we are aware that there's no possibility of recovering this money, but it has to be done. We have to help our people who are in distress. And regarding people in the Gulf, all our embassies have special staff there who are trained to work with the local Indian workers who are there. We are aware of this problem, which is why the process of the protector of immigrants was evolved, to try to reach out to these persons and to tell them that they should know where they are going, what they are doing, what is the job they are going to have, and all those kinds of basic information. Now, another category of persons which was mentioned is like the abandoned spouses, or spouses whose marriages have broken, if they have not worked. Here again, the government is making efforts. We have been in touch with law associations of the Indian communities abroad, and in many places we have legal advisors who can help these persons. inside. But as you could understand, the extent to which government can help them is limited because we have limited number of missions, limited number of consulates. We cannot cover the entire territory of a large state. Say in a large country like the USA, we have 5 consulates. So obviously they cannot deal with all the persons, and everyone who is in need of help is not in a position to approach the consulate. So we cannot even know who is in need. Now coming to the other issues, apart from these areas where there is a conflict, private international law also deals with areas which help persons who are traveling abroad for work or study, etc. And these are areas where there is no conflict. Like some of you students may, after you complete your basic law degree, want to travel abroad to go and pursue a higher course. For that, when you apply to a foreign university, your documents, your educational certificates, your birth certificates, etc., they need to be authenticated. Now, this was a long process earlier, where the documents were first authenticated by the local authorities in the state or by the Ministry of Education, and then by the Ministry of External Affairs, and after that by the embassy or the consulate of the country in which these documents have to be produced. India has joined the Hague Convention, which is popularly known as the Apostille Convention, although more formally the name is the Convention abolishing the requirement of legalization for foreign public documents. So any public document or a document issued by a public authority, once it is certified with the apostille, it can be directly produced in any member country which is a party to the Apostille Convention. And here the process is simple. The apostille is fixed by the Ministry of External Affairs after getting the document certified by the state government. Then it does not need any further authentication from any embassy of a country which is a member of this convention. In the case of litigation where one of the parties is in India and the case is filed abroad, service has to be effected on the other party. For this, India has joined the Hague Convention on service abroad in civil and commercial matters. So this is now, there is a verifiable method of serving documents on parties to litigation. And this avoids a lot of cases where earlier the complaint was that the party in India had never received notice that there was legal proceedings initiated against them. Now, when the legal proceedings are initiated, the need for evidence would arise. And if the parties are in different countries, then there's a need to issue commissions. Here again, there is a Hague Convention on the taking of evidence abroad, to which India is now a party, and the process has been much simplified. Now, there were 2 areas in which there is a lot of litigation for NRIs. These have been highlighted in the earlier statements. One is the question of breakdown of marriages, where one party to the wedding gets a divorce decree from a foreign court. And as you're aware, there are many places, even in the United States, where it is very easy to give a certificate or a declaration that you have resided there for a certain number of days and that you intend to reside in that state, and that confers jurisdiction on the court. And on that basis, they file for divorce and it is very easily granted. Now, the other spouse who may be in India is not even aware. And when they ask for maintenance or they have some other issue comes up, then the person says, I'm already divorced, you are not my wife. The well-known case of Satya versus Teja had laid down a very important principle of determining as to whether such divorces can be recognized in India. And in that case, the Supreme Court examined a divorce decree granted by a court in Nevada. In this case, the wife had never been to the USA. She had all along been in India while the husband went there for studies and then later took a job. And after that, he went to a Nevada court, made this declaration of residence, and got a divorce. The Supreme Court here went into the question by examining whether this divorce decree would, in the first case, be recognized in other parts of the USA, and came to the conclusion that it would not be recognized. And on that basis, the court said, if it is not recognized in the US itself, there is no question of it being recognized in India. We have had a number of cases where such divorce decrees have come up for examination by Indian courts, and these principles have been reiterated. However, there is now a new situation that very often both the parties to the wedding, they have actually become citizens of the country where they have moved to. But when something went wrong with the marriage, one spouse returns to India and files a case in India, and the other spouse, staying back in that country, gets a divorce from that court. So this is another area where I think the Supreme Court or our courts have to examine as to how to deal with these. Mention was made of the judgment where the Supreme Court, Nirja Saraf and Jayant Saraf, where the Supreme Court made a suggestion that no marriage between an NRI and an Indian woman which has taken place in India may be annulled by a foreign court. Well, it may sound very good and in favor of the stability of a marriage, but question is, how practical is this? Especially if both parties have become citizens of the country where they are living. Can we still assert jurisdiction that on the basis at that particular time they were Indians, or that when they married they had Indian citizenship? Can this claim of jurisdiction sustain forever? Then there was also the suggestion made that the decrees of Indian courts should be made executable under Section 4 by reciprocal arrangements under Section 44A of the CPC. Now, this reference to Section 44A, how relevant is that? Because when Section 44A speaks of the execution of decrees, the decree here is essentially a money decree, where a certain specified amount of money is to be paid by one party to another party. And marriages certainly cannot be covered under that. So I think the courts have to examine this issue. For how long can you hold on to the fact that the persons are Hindus or that they were married here under the Hindu Marriage Act? Now, this also breakdown of marriages also leads to the other very important issue, which comes up regularly and which Mr. Malhotra has highlighted, that is the parental child abductions. We have a number of cases where on breakdown of a marriage or when something is not going well, one of the parents will take the children and bring them to India, and you have then litigation in both countries where there may be custody orders given in abroad, and then the other parties are asking the Indian courts to give them custody. Here again, while the courts have been emphasizing that they will take their decisions on the basis of the best interests of the child, there is no uniformity of thinking in the court as to how to deal with these issues. Every time the matter comes before the court, you'll have in one case, primacy is being given to the convention, to the need to abide by a rule which is now being followed by more than 100 countries. On the other hand, you have then the next judgment comes along. The court wants to chart its own path, forget the international practice, and then say only we can decide the best interests of the child. So I think this is a position which needs to be more carefully considered. Why do Indian courts consider that a foreign court will not consider the best interests of the child, especially a court where the child was born, where the child has lived for a number of years and where he has been brought up? How can we suddenly say that this court is not competent to look at the best interest of the child and only I can do that? So this is another issue which I think our courts need to look at. Now, coming to some of the other areas which has been highlighted in this book, I'm very happy that one of the areas which Mr. Anil Malhotra and Ranjit Malhotra have taken up is the question of succession to property. This is an area which is becoming increasingly important because large number of Indians have settled abroad. They're working there. They have properties in that country. They also have properties in India. Maybe they have properties in a third or a fourth country. Because, as you know, Indian professionals in the West have done very well. Now, a time comes, of course, when they need to consider what will happen to this property after they pass away. And they face issues like, how do I make a will when I am located in one country but I have properties in several countries? The procedures for making a will, are they the same? Are the attestation requirements the same? Should it be registered in only one country? Should it be registered in more than one country everywhere? Now, the issue becomes more serious because when the will involves immovable properties in more than one country, in general, the courts of one country will not recognize a judgment from another country when it deals with immovable property. For example, in the case of immovable property located in India, Indian courts will not recognize the jurisdiction of any foreign court to deal with that property or in respect of that property. And similarly, other countries also. So these are problems, and I'm very happy to note that in this particular volume, a lot of space has been devoted to issues of succession, which earlier was just sort of glossed over. So, and I thank Mr. Malhotra, both the Malhotra brothers, for that issue. Now, where does India stand on these conventions? Now, when marriages break down, of course, we find that this is an increasing occurrence even in India. But after the marriage has broken down, there is the need for then providing for maintenance for the spouse and the children. And this is an area where there's a Hague Convention on maintenance abroad, recovery of maintenance. There's also a UN convention. And I have recommended to the government that India should consider joining these two conventions, because India does have a law on recovery of maintenance abroad, but there are very few countries with whom we have this reciprocal arrangements. And we have not seen any data at any time as to how this law is functioning, how many requests are being made for recovery of maintenance from those countries, or those countries are making to India. And it would be advisable for India to join these new conventions. Now, even on the Child Abduction Convention, as legal advisor to the Ministry of External Affairs, I had recommended that India should join this convention. And this was in the year 2006. I was very happy when initially there was a very positive feedback. All the concerned ministries and departments, they readily agreed, yes, that it would be beneficial for India to join this convention. But then the question came up of drafting the legislation. And that legislation is still not complete. In 2016, a draft legislation was placed on the net for comments. I had also given some comments on that. And after that, we see that there has been no movement at all on this matter. So with this, I have already taken up more than my allotted time, and I would like to conclude here. And once again to thank Professor Gurpur and Symbiosis Law School and Mr. Anil Malhotra for including me in this important program. Thank you.
Thank you, Mr. Narendra Singh, for expressing your views on communities that have been in legal and humanitarian distress through the immigration laws and policies. You also touched upon the legal issues surrounding family law matters, especially with respect to immigrants. Thank you for bringing your expertise to the discussion today. Thank you. I would now like to call upon Ms. Reshma Samvari to deliver her comments on the topic from her unique lens as an attorney and a social worker. Welcome, ma'am.
Thank you. Well, thank you all. I'm honored to join this panel of esteemed leaders and practitioners in the legal field in India. Honorable Justice Muralidhar, Advocate Malhotra, Mr. Narendra Singh, and of course, Dr. Gurpur ma'am. It's my honor to be part of this panel. First of all, as I mentioned earlier before our panel discussion started, that Mr. Malhotra has gotten at least one true global Indian here on the panel. I'm joining you from Michigan, and it's 4 a.m. right now. So it's my pleasure to be here on the panel, of course, and contribute my views as a practicing lawyer and a global Indian for the past 20 years. I had prepared a lot of notes, of course, to share with you based on my experiences on commercial side and the private law side that I have been personally involved in the almost 2 decades. But I'm pretty sure being the last speaker on the panel, I'm probably crunched for time. So I will make it very short. First of all, as mentioned by Mr. Malhotra and his brother in the book, that I've been an NRI, a PIO, and an OCI, right? So it's a journey that every global Indian goes through, and how our legal rights change in India and abroad, depending upon your country of residence based on your status, right? So when I'm an Indian citizen, how am I treated versus when I become a PIO or an OCI? What do I lose on the India side? What do I gain on the country of residence? And it's very nicely handled by and addressed by Advocate Malhotra. I have to give him and his brother a lot of credit, because as many of the reviewers of the book have mentioned, that most practitioners have been working in this area almost like blindly, right? Because we have not had a book like this before as a reference book. I almost called it a treatise. I think it deserves the status of the treatise, because the amount of detailed work that has been put into this book, not only from case laws and statutes, but also the real very timely issues that have come up among global Indians from various countries. As we have mentioned, that there are over almost 30 million NRIs in more than 200 countries. So the first time when I heard the title of the book, unfortunately, I couldn't get a hard copy delivered here to the US. So I had to rely on my screen reading, not my favorite method, but still. And I was trying to visualize what it could encompass. 200, so these 30 million Indians, NRIs, are subject to the laws of not only India, but laws of 200 different countries and international bodies of laws, right? So what can the book deliver? Then I thought, okay, I think the title for the book should probably be Indian Laws for Global Indians, right? So it's just talking about the Indian laws for global Indians, and that may be more apt, I would think, for a layman who's not in the legal practice. The second aspect of the book that really I appreciated the most is just the very comprehensive set of cases, and not just from the Indian courts, but also from some of the very few, but some of the foreign courts. And it would help tremendously for practitioners like me to rely on that body of law and then help our clients on a day-to-day basis. The third thing I wanted to address, and I think I will skip most of my notes based on my actual case law, and just simply go back and add to what Justice Muralidhar had started discussing about certain type of global Indians, because the book certainly addresses highly skilled, well-documented, and well-traveled global Indians, right? But it doesn't in detail doesn't address a large section of global Indians that could be undocumented, or that could be come under the category that Justice Muralidhar addressed. The second category that I have personally come in contact with are the Indians who are in merchant navy, right? So global Indians who are in merchant navy, they're merchant navy employees, they're cargo handlers on the ships, they're sailors, and it's really difficult to decide their domicile at any given point of time, even though they are nationals of India. And so that also has very different, those NRIs rather, present a very different set of issues that could be handled. So what I would like to do is simply just focus on, I'm a fan of your book already, but what I would like to give you, Advocate Malhotra, is a short list of areas where I really want to request you and your brother to come up with a second volume of this book, because I've been practicing as a global Indian lawyer in nonprofit, in NGO, and also in the commercial sector as a partner with one of the local law firms here. And the list, what I would look at as the most valuable to us, where we run into issues every single time. And I would like to share that with you, not as a critic, of course, and I hope you take it in a positive note, because it will be most helpful to us as students of law, for lifelong students, and also practitioners at an international level. Now, since my exposure has only been in India and the United States, I will try to stay close to those two countries. So the very first is, of course, what the type of global Indians that I have had to deal with, the merchant navy employees, right, who are also NRIs and have extremely different set of issues that could be handled. The next area that I have been doing a lot of work in is domestic violence victims, and many times the issue with the victims of domestic violence, if they are in the United States on temporary visas, the problem with them is that as soon as they go through the divorce process here in local courts, and as all of you experts have discussed, that how the local court shouldn't even have jurisdiction over their marriage, because majority of the time they have gotten married under Hindu Marriage Act in India, under per the Hindu rituals, and they have not been married in the United States the second time. So really the local courts technically, legally should not have jurisdiction on their marriages. But the way we establish here, the US courts, the way they establish jurisdiction over in personal jurisdiction, they can easily establish that jurisdiction and grant them a divorce. Whether or not that divorce is legal in India, whether that can be enforced as is without going through the second round of court proceeding or through the embassy administration of the divorce is, of course, we've already discussed that, and the book goes into a lot of details for that. One area that I have noticed in the book that could be expanded is the role of the embassies in administering the matrimonial court orders, the child custody orders, property division orders, because I think particularly in domestic violence matters, Delhi High Court has instructed Indian states that they could rely on embassies a lot more in expediting the enforcement of such orders in India, instead of going through this mirror jurisdiction, it's called, right? Mirror, let me see, what's the exact phrase that you use there? If I can find it.
It's mirror orders.
Mirror order. Okay.
Mirror orders.
Okay, so the mirror order jurisprudence. Yes, exactly. Because not everybody has the time and the money and the resources to go through that process, because it cannot happen quickly. And majority of the time, if they have minor kids involved, perhaps the route of going through the embassy administration of their United States court orders in the matrimonial matters, in the domestic violence matters, could be one area that you can explore further, because that would be most helpful in majority of the cases. The second issue that is that we mostly face in domestic violence matters, or even other, when there are breaks in marriages of global Indians in the United States, most of the times the wives they are on dependent visas that are associated with their husband's work. So when they get divorced, and if there is domestic violence, first thing that happens as soon as the divorce is effectuated is that they lose their status of the dependent visa on their husband's, attached to their husband's work visa. But I serve on this pro bono panel at the state level here. It's called VAWA and U Visa. VAWA stands for Violence Against Women Act, and U Visa is one of the category U, section U of the USCIS code. And both of those grant certain remedies to victims of certain classified crimes, and they can apply for certain special visas to continue to stay in the United States, particularly when they have very young kids who need some kind of assistance from their father, or they're going to school here, or there is no family support back in India, who are not approving of the divorce and they don't want to accept the woman back in their Indian families. So majority of the time, what happens is when we apply for that kind of remedy, these women are stuck in the United States for years. They must stay here. They are not allowed to travel outside of the country until their remedy is approved. And under the current administration in the United States, these remedies are not looked at favorably, meaning that the processing of those applications get delayed for years. Initially, when I used to get those kind of applications approved, let's say 10 years ago, it used to take me 12 to 18 months at the most. Now it's taking 3 to 5 years, meaning these women are stuck in this country with their minor kids by themselves for that period of time. So they may have property back in India, they may not. They may have any kind of resources back in India, they may not. So as Mr. Narinder Singh mentioned, that how long can Indian courts exercise some kind of jurisdiction over them? How long can that connection of domicile be established on these global Indians if they have no property connection or no other residence connection back there? So it becomes really difficult to even access what is back in India, because they cannot travel, and then they cannot access the courts back in India for any additional remedies. So that's one area. The second is, of course, in those cases, the husbands generally who have been abusing their spouses try to funnel a lot of money back to India. They try to buy a lot of property back in India in their brother's name, in their father's name, in their mother's name, so that nothing goes to the wife. Now, of course, under the US laws, all of that would become what we call marital property and would be subject to division here. But when it is back in India, the local courts simply throw their arms in the air saying, we don't have jurisdiction over that. If you can prove it's marital property, we will try to bring it here, but there is no way we can help you to enforce the judgment back in India. And when women are stuck here for years, particularly if they are going through this VAWA or U Visa type of remedy, then most of the time they end up losing on their share of property. Not only they, but their kids also, right? So that's another area as to, I'm looking to you as solution provider, because you are there and you have been practicing for decades, all of you. And when you write a second volume of your book, if you can address those areas, not only from the jurisprudence point of view, but also from policy point of view, that will be most appreciated by practitioners like me, and of course the beneficiaries of that. The third point I would like to make is that many a times OCIs, let's say overseas citizens of India, are getting married in foreign countries, right? In foreign countries. So when they come to India, and after coming to India, if one spouse gets abandoned by the second spouse, can the local Indian courts have jurisdiction over them to grant them divorce or to grant them any other remedy? So sometimes, again, they could have the OCI status or some kind of NRI status. They're getting married in foreign country. They return to India, and one spouse abandons the other spouse. And that through that abandonment, now the spouse who has been abandoned doesn't have any way to return to the country of residence. And what are her legal rights in the local courts? Those are completely unanswered issues for us. And then we have been trying to figure out how to help victims in those cases in India. Like, which court can they go to if they have no domicile or no property connection or no connection to India as such, other than, let's say, if they can establish citizenship through their ancestors, right? So that's one area. The next one is one of the types of cases that I also handle are called SIJS. Special immigrant juvenile status type of matters. What these cases represent are minor kids from India who have been abandoned by their parents, either while they were in India or somehow they made their way to the United States and then they were abandoned. It's unfortunate, and we may not hear about those things, and we may not believe that such things happen in the United States, but they do. In large numbers, unfortunately. So what happened, let's say, I'll give you one example. So this was from Punjab area. The kid was very young when his father remarried, and he abandoned the first wife. So this kid was from the first wife. So the father remarried someone else, the second wife had kids, and then the kid's mother died when he was only 4 or 5. So now the father didn't want him, but the whole village went to the father, said, look, he has no one else, you have to take him. So the father took the kid, and then the father went to Italy for some reason, for some, I don't know, work or business. He took his second wife, kids from the second wife, and the child from the first marriage. And then when they were in Italy, apparently the second wife caused a lot of issues and saying, I don't want this kid here. He is not good for our relationship, whatever the reasons. So the father abandoned the child in Italy. Okay. So now here is the Indian citizen child, a minor kid, completely abandoned by his father in Italy. And then somehow Italian embassy, the Indian embassy in Italy was able to locate some community member from his village in the United States. So they managed to make that connection and send the kid to the United States. Somehow that case landed in my lap through my NGO. And then now we are working on it. How? Like, he has nowhere to go in India. He doesn't have any connection to Italy. No biological parents are available there to take care of him. So then how do we establish? That's what comes under special immigrant juvenile status. So we went through for years, and we got him the green card and the US citizenship in India, found a family as his local guardians. But what happens to his claim to his father's property back in the village? Can he come back to India and claim any share of his father's property, who seems to have a lot of property back there while he's living as a very poor kid on public charity in the United States? So people like me, we would like to help the child to claim whatever is his through his parents back in India. So those are types of issues also, as to how do you claim inheritance when you have not been part of the family, not been living in India. How can local courts establish jurisdiction over you, or what kind of remedies, and where can you go to establish that kind of claim on your family property? Then Mr. Narinder Singh mentioned wills for global Indians. One thing just one short point about that is that when can a global Indian create one will for his global properties, right? Or does he or she have to create a separate will for separate jurisdiction? Like if I have home in India, home in the United States, home in England, can it be just one will? Is there a way to create one document that's just complete and can be enforceable in every jurisdiction where I have immovable property and movable property? So that's a big, big area that particularly with aging population of Indians who have been migrating abroad since the 60s are now coming home to roost, right? They have retired, and then they are the ones who are looking for such kind of help in large numbers, but we don't have standard answers for them. So we have to take it case by case and try to figure out a solution for them. So that would be a great help for practitioners like us. And the last area is, of course, more about investments, right, and taxes. A lot of global Indians, most of the time, they want to know, how do I bring my money from India to the United States? How do I take my money back? Can I, after I retired, can I continue to collect my Social Security benefits from the United States and live in India? Like if I live in India and collect this income, how much more can I earn in India and still avoid double taxation? What are the taxation laws? What are the limitations on my money transfer between the countries? And then the last point there is, and of course, acquiring real property, running a business. If I'm a U.S. citizen with a OCI, can I live in India and run a business? Can I acquire a business? What kind of real property, meaning immovable property, I can acquire and I cannot acquire, right? And then what happens if I run into bankruptcy issues in India? What happens to my personal assets there versus can the courts reach my assets back in the United States? And lastly, if I form some kind of charitable trust, and if I'm an OCI person living in India, how do I bring funds to help my charitable work in India? What are the FCRA regulations, and what are the do's and don'ts so that I don't run afoul with the Indian laws? So these are some of the highlights of the areas that I just wanted to point out, because you have done, I think this is your 9th book, so I can see one more, at least few more coming out. So I didn't want to miss this opportunity to give you, highlight the areas which I think practitioners like me across the world could really, would appreciate it highly, particularly us who are working with global Indians. So thank you for this opportunity again.
Thank you, Ms. Reshma Sambare, for expressing your valuable insights and reviewing the book and relating the same with your personal experiences. You brought out some pertinent questions relating to the protection of women and children abroad and the serious legislative and policy lacunae related to them. Certainly, the rich deliberation by the panelists has stirred up some intellectual curiosity. And so now we will be moving into the question and answer session. To moderate the question and answer session with the audience, I will now invite Professor Srimanti Chaudhary.
Thank you, Lhasa. And a very good afternoon to all the esteemed panelists present here. It was a very vibrant and rich discussion on topics that are very relevant in today's time. And we had asked our students to send in their questions beforehand because so that we know what kind of questions we are expecting. And they have sent in a lot of exciting questions, which I will now pose to the panelists if I get their permission. Should I go ahead with the first question?
Please do, please do.
Yes, sir. So the first question is with respect to surrogacy and rights of a child born out of surrogacy. And it says if the intended parents refuse to take the child and refuse to take up the responsibility of the child born out of surrogacy, are there any provisions in the Indian law in order to protect the rights of that child?
I'll take that question.
Yes, sir, thank you.
Now, to put it very bluntly, the law on surrogacy is yet to take birth, though the surrogate child has been there for 10 years. We have let surrogacy go on through ICMR guidelines of 2005, but we have not made any law to regulate surrogacy. We have not created any infrastructural mechanism to enforce rights through surrogacy. The only ad hoc arrangement that is existing is through agreements. So through the agreement, there is a duty-bound contractual obligation for the mother to hand over the child and for the parents to take the child. Now, sadly, sometimes when children are born with abnormalities or problems, there is a tendency to not take away the child. Then often the hospital or the nursing home reports the matter to the police. The matter is sort of compromised. But unfortunately, we have developed a system of surrogacy, but we have not been able to bring in a mechanism to take care of the problems. So this is a gray area. And except for moral and other pressures, there is no real force in any system or through a court to enforce such rights.
Thank you, sir. So this is something in relation to, again, child rights and inter-country adoption, the next question. One of the students is asking that how well developed are the laws with respect to inter-country adoption that they try to prevent incidents of trafficking? So his question is very blunt to the point that are there enough international laws or even at the national level which is efficient enough to take care of situations of child trafficking?
See, as far as this is concerned, this is one area where India has solved the problems. Mr. Narinder Singh will bear out with me that the Hague Convention on Adoptions of 1993 has been signed by India. And to make sure that the obligations in the Adoptions Convention are put in place in the Indian legislation, we have made successive changes in the Juvenile Justice Care and Adoption of Children, Care and Prevention of Children Act 2015 by putting in all the provisions of the Adoption Convention and also of the UN Convention on the Rights of the Child, which also India has signed. We have created a special chapter on social integration and rehabilitation of children through adoption. We have made JJ rules. Then most importantly, the then Minister of Women and Child Development, Menka Gandhi, was very emphatic in making the adoption regulations 2017. Now, because we signed the Hague Convention on Adoptions, we had to be a signatory country. We had to create a central authority, and Central Adoption Resource Agency has now become Central Adoption Resource Authority, through which the entire process of inter-country adoptions takes place. The beginning of all this was Lakshmikant Pandey, 3 judgments, 1996, 1998, and 2000, by which trafficking of children was a conscious issue. So those judgments have actually percolated down into these adoption regulations. Now the trafficking of children is almost over. All inter-country adoptions go through CARA. Central authorities of different countries get in touch with the central authority, that is CARA in India. You get into a queue, you get a home study, then there is evaluation, then there is a court order, and then there is a CARA NOC. So trafficking is now something which is very difficult to do in vis-a-vis children is concerned. So adoptions is one thing which the law has taken care of, happily, of course.
Thank you, sir. Yes, sir. Narinder Singh, sir, would you want to make some comments?
Yes, I would just like to add to that,
yes, sir,
that before the Hague Convention was adopted, we had the judgment on the Lakshmikant Pandey, in which the Supreme Court had laid down some guidelines to be followed in the case of inter-country adoptions. And some of these guidelines have now been incorporated into the Hague Convention.
Thank you, sir. This actually brings me to the next question, which is based upon the rights of child under the Convention on the Rights of the Child, and how it juxtaposes itself with this confusion or conflicts that are created due to applicability of multiple jurisdiction on the rights of child born out of marriage, which may have happened between parents of different nationalities. And this is with respect, again, with foster care child and India's response to the foster care system. So we have seen and we know of a lot of cross-cultural interactions that foster care concept is very well developed in US and UK, and we see a lot of situations where children in unhappy homes, in homes which are not comfortable or conducive to their well-being, being taken up in the foster care, and from there they are sent to families where they can be taken care of. In Juvenile Justice Act also currently there is a mention of foster care, but we have seen that the system is not as developed as or as systematic as we have seen in they operating countries like USA and UK. What would be the panelists' opinion with respect to development of a foster care system in India and the governing legal framework? What should it entail?
See, as a practitioner, I have dealt with these issues to a great extent. Now, whenever we see a child custody dispute, we lose track of the fact that this is actually about the rights of a child. So I have, in my recent arguments before courts, started talking of the rights of the child. And I have based my arguments on the fact that United Nations Convention on the Rights of the Child, UNCRC, was ratified by India. And all the beneficial provisions of the rights of the child to a home, to a family, to a nationality, to live in a country of his residence are actually incorporated in the JJ Act. The only enactment which defines the best interest of the child is actually the JJ Act. Till now, the courts would tell me, listen, you are talking of an enactment which does not apply to normal children. This applies only to children in conflict with law or juveniles. So I have said this act also applies to children in need of care and protection. So if there is a child whose rights have been violated, maybe by a natural guardian or a parent, he needs protection. So happily, to my satisfaction, this definition of the best interest of the child from the UN Convention on the Rights of the Child is now being taken in child removal matters. Now, vis-a-vis foster care is concerned, you see, unlike the West, what is our foster care system? Our foster care system is grandparents, brothers, sisters, masi, bhua as we call it, or extended family members. Because we are extended families, we are not single parent or dual parent families where parents, let us say in the US or in a foreign jurisdiction, maybe just the husband and wife. So if there is a dispute, the child goes to foster care. In our country, children don't go to foster care when there are natural parents alive. They go to extended family members. The mother goes to her parents. The father may choose to go to his brother or his sister, etc., etc. So, but vis-a-vis children abandoned, children neglected, children abused, or children with no parents, the JJ Act has got a complete machinery now. Abandoned children go to social service. There is a public notice. After that, they are moved into an orphanage or a child care home and they are put up for adoption. So, for abandoned and children in conflict with law, there are homes, there are special places now. And that infrastructure has developed because of a statutory mechanism. Insofar children with both parents are concerned, you often find parents going to the guardian court for exclusive custody because we have not developed any guardianship mechanism under the Hindu Minority and Guardianship Act. So for their litigation takes place and the foster care comes through the parents. Now, in overseas jurisdictions, there is always the fear, as my friend would point out from the US, that whenever there is a problem, it's a problem with all Indians. You beat your child, the foster care takes away the child. So their system, their method of evaluating foster care and need for your child to go to foster care, their social practice, their cultural values, I mean, the mores are totally different. So you have to take this with a pinch of salt. If you live in the US, you have to learn to respect US laws. I think my friend would bear me out on that and add to that.
Yes, sir.
No,
Thank
I agree with you 100%. I don't
Yes,
have anything
Reshma
to
ma'am,
add.
would you?
Okay. No, I agree with Advocate Malhotra 100%. I have dealt with quite a few CPS, we call it, Child Protection Services matters here, because Indian parents, it takes them time to learn the US laws, and if they continue to follow the punishment methods that they are used to in India, it doesn't go well here under the US laws. So they run into some issues with the CPS. And if it is a severe one, then CPS can remove the child and put it in a foster care until parents go through certain months long versus worth of training courses, take exams, go to a court and under oath give some kind of affidavits that this will not happen again. And if it does, then they may lose their child to foster care until the child turns 18. And it has happened. So yes, Mr. Malhotra is right that they have to follow the laws when they're here, the local laws.
Something.
And there's one issue which I would like to talk of, which Reshma had addressed about the abandoned children in foreign jurisdiction. Now, I dealt with a matter like that. There was a young child, 6-year-old boy, who was abandoned in the streets in England, Southall, by his parents who were illegal immigrants themselves, and who thought that the Britishers would give him British nationality. Now, the local council took him in care, and they tracked down his uncle in a village in Punjab. They sent a social worker who tested the DNA, and it proved positive. Now, the uncle said, listen, I'm willing to take on this child. But the question was, how would the child leave the country and how would the child arrive in India? So when the social services people approached the Indian High Commission in London for a passport, they said the boy has already got a passport. We can't give you a passport unless his parents come and say they've lost a passport. So that is the time I filed a writ of a mandamus in the Punjab and Haryana High Court on the behalf of the Borough of Ealing, directing the MEA and the High Commission in London to give him a travel document. And the High Court did issue an order that this boy should be given an emergency travel document to travel from London to Delhi. And then through a social worker, the boy was taken by the uncle. He was produced before a guardian judge. And the 9-year-old boy said, listen, I can tell you better tales nobody has ever heard. And his uncle took him in care. So there is a mechanism. All you need is some innovation, which as a lawyer I have done, but this is something to share it. It's Gurinderjeet Singh. You might find the case somewhere on YouTube also. Yes.
Oh. Thank you, sir. And thank you, ma'am, as well. Actually, this brings me to the next question, which is with respect to use of domestic violence by parents, which Indians tend to do to teach a lesson to the kid. And the question is with respect to the increasing trend of filing false cases of domestic violence. And whether the time right now is ripe to have a special legislation in order to counter action against persons who file such false cases, or whether there is a bigger danger of law being used and abused against the victim if the other party has more financial power or more, have a higher social status. If under such circumstances, will it be a possibility that any such legislation or legal action can be misused or abused against the victim? So it's a question of how to balance out in law. And this student is asking that whether, how the law should be addressing it. Over to you.
I'll take on this question straight away. See, I have in litigations recently started observing that for violence suffered in Cape Town, in London, or in New York, the domestic violence petition is filed in Delhi, Mumbai, or in Jalandhar. Now, the larger question is, can domestic violence suffered in a foreign country be a subject of adjudication in India? See, happily, the IPC is very clear that the IPC has extraterritorial application vis-a-vis Indian national, or only on Indian soil. It has no extraterritorial application. That is section 3 and 4 of the IPC. So if you have a mother-in-law sitting in Dubai and a lady coming to Delhi and saying my mother-in-law beat me up, the IPC will not apply because the woman has never been to India and she doesn't live here. But in the Domestic Violence Act, under Section 27, it is said that the woman has the jurisdiction, or the court has the jurisdiction to file a petition where the wife is residing. Now, I have tried to unsuccessfully argue before a court that this is only if the domestic violence is suffered in India. You live in Nagpur. You have come to Delhi, where your mother lives, and you have a right to file a violence petition because the domestic violence has been suffered in India. But can you extend the jurisdiction of the Domestic Violence Act to South Africa, to New York? No, I would think no, but the court didn't agree with me. They said this is a beneficial legislation. Now, what has started happening of late is, see, under the Domestic Violence Act, you can get an order faster than you can in any other system or in any other litigation in India. All you have to do is file a complaint before a magistrate, and you can get an ex parte order. You don't have to lead evidence, and in the proceedings are supposed to complete within 60 days. It's a summary procedure. So you can get a residence order, you can get a maintenance order, you can get a right of residence to live in a shared household, you can get a custody order. So what do? You get a custody order of your child in a domestic violence petition. Now the question which a foreign court asks is this custody order in a domestic violence petition a final adjudication? The answer is grey, and the answer is no to a certain extent, because you have to go under the Guardian and Wards Act to the family court to get a custody order. So yes, there is an abuse of the DV Act. There is, to a large extent. See, what is done is you file for maintenance under 125 CRPC, you file an FIR under 406, 498 IPC for cruelty and harassment, you file a domestic violence complaint, and in some metropolitan jurisdictions, it is fashionable to file an anti-injunction suit also. And then you also file a divorce petition. So before the other spouse comes to India, you tell him, listen, you have 6 litigations. So the poor chap says, thank you very much. I'd rather stay here. So I think what is happening is that the plethora of laws adding to the misery of a spouse, which is going to be used to settle scores, has become, I think, it has become counterproductive. We really need to sort this out. So you have this domestic violence things before a magistrate. You have a 125 CRP before another magistrate. You have the 406, 498A before a criminal court. And you have the divorce petition before the family court. So how much time can an American, British national, or any other person spend in India? And the first thing they'll say is, please deposit your passport in court. And if you do that, you'll never get your passport back. So it's a pretty awkward situation. I'm not taking gender sides, but it is a lot of counterbalance wrongly done.
Thank you, sir. So that brings me to the next question, which is on prenup agreement.
Can you go back to this question?
Yes, sir. Yes, sir. Please, sir.
I just want to add to what was just mentioned by Mr. Malhotra.
Please, sir.
Well, you have the abuse of process in the domestic violence law. Then there's the question of dowry. You can have the abuse of the process in there. Then recently we had the law on atrocities against scheduled caste and scheduled tribes. That became a very big issue, with the Supreme Court giving a judgment that the matter should be investigated first before the person is arrested. And then there was a big agitation against changing the law. So this possibility is always there. And I don't see any easy answer to that. Thank you.
Thank you, sir. So next question is with respect to prenup agreements and their execution and enforcement in India. So the question is very simple. It says, are prenup agreements made outside India be executed in Indian courts, and whether when either one of the party is an Indian citizen and the other party is a non-resident Indian. So in case an Indian enters into a prenuptial agreement with a non-resident Indian, what will be its status of this particular contract in under Indian law, and whether can it be executed and enforced in India?
See, the one-line answer to this is prenups are illegal and unenforceable in India. And the logic, the reasoning, and the justification is, see, in India, a marriage is fundamentally a sacrament. When you marry under the Hindu Marriage Act, and that takes care of Reshma's question also, if you were to marry under the Hindu Marriage Act through a traditional Hindu ceremony in the US, and you would get your marriage registered in the consulate under the Foreign Marriage Act, you can still invoke the Special Marriage Act in India for getting a divorce or taking a matrimonial remedy. Obviously, if you marry under the civil laws in the US, that would be a different question. India would not be able to adjudicate that dispute. Now, we look at a marriage as a sacrament. That is why registration of marriages under the Hindu Marriage Act is not compulsory. So marriage is not a contract. It is a sacrament. It is a religious thing under Indian family law. If you marry under the Special Marriage Act, though, that is different. So therefore, now in the West, a marriage is a contract. Your registration is compulsory. Your church marriage is optional. So when you want to dissolve a marriage in the West, you go and ask a court to dissolve your marriage. You don't have to explain why. You don't have to say or justify the reasons for so. You will simply get a divorce for the asking, except you have to settle your matrimonial property and child custody for confirmation. So in that context, in the West, in a contract, you decide before you enter into the contract how you will dissolve the contract. That is a prenup. In India, we don't do prenups. In a traditional Hindu family, if you talk of a prenup, they probably think you don't need to get married. So it's a different scenario. It's a different culture. It's a different society. But let me tell you, if you travel towards the south or towards certain parts of other parts of India, where two high-income groups are involved, the man and the woman are earning equally high, they do a prenup before they leave India, because they know they are going to the US and they want to be very clear about what is going to happen. I have drafted prenups. They are not enforceable in a court in India. If you actually produce a prenup before a court in India, you are looked upon with a negative view, saying, how could you do that before marriage? So it doesn't help you. So the bottom line is, a prenup is a no-no.
Just out of curiosity, sir, and because I also teach contract, this question has been lingering in my mind for quite some time. Is prenup, can it be enforced as a contract between two individuals?
It's against public policy. So
okay.
Basically a fundamental violation of the Contract Act.
Contract Act, yeah.
Yeah, you see, because it is a contract not allowed by Indian law.
Yes, yeah, public policy.
It's plain and simple.
Yes, yes.
So, it's a void contract.
Thank you, sir. Thank you for this. And the last question is something which is very valid in today's time. And some student has asked, like during this pandemic, when international travel was restricted or banned for most countries, and there were couples who were supposed to get married stuck in different countries, and they decided to get married virtually through any mode of like video conferencing or something. Will the legality of that marriage be in question in any circumstances, or will the jurisdiction change just because one of the spouse, though resident of India and citizen of India, was stranded in another country from where he entered into the marital obligation through a virtual mode? Will that impact the legality of the marriage in any?
I don't think you can do a virtual marriage under the Hindu Marriage Act. The simple reason is you have to do the ceremony. And what is the ceremony? In the Hindu mythology, the Lama Fere, 7 times around the fire. In the Punjabi culture, around the holy book. So unless you tie yourself to each other and go around the fire 7 times or the book 7 times, you can't do that virtually. Now you could do your registration in the foreign mission or something under the Special Marriage Act. But I think a traditional, conventional Hindu ceremony would not be possible because there is no ceremony. If you're not there together, then where is the marriage? Mr. Narendra Singh might be able to answer that better.
No, I agree with you.
Yes. We don't have Justice Muralidhar. We could have put this question to him to say, how would you decide this case? But let me tell you the global Indian thing, I've been stuck with a riddle, which is actually the global Indian problem. Now, I have been asked by a borough in England to help them in adopting or relocating a 3-month-old child who is born to a woman who is now a British national, whose parents came from China, but she's Tibetan, of Tibetan religion. She came to England when she was 9 years old on a scholarship. She obviously came on a travel document, which the Tibetans have. Now, she is there is a relationship she has got into a man who's a British national, who's an alcoholic. She's herself studied very well. She became a banker, but she went down in life. She's a substance user. She has gone astray. She can't handle the child. Now, the Britishers want to know if her Tibetan sister living in Karnataka wants to adopt or be a guardian to the child, what would you do? Now, this sounded more like a moot proposition. But then, where is the answer? So, I found the answer in Justice Muralidhar's judgment. Namgyal Dolkar, Tibetans are Indians. See, all Tibetans who came from between 1950 to 1987, according to his judgment, should be given Indian citizenship. But what of those Tibetans who don't want to become Indians? So, we treat them as foreigners. We don't call them refugees. So, I have handled the proposition to say that these Tibetans are Hindus. So if you are Jain, Sikh, Buddhist, you are a Hindu. So if you are a Tibetan, you are a Hindu. If you are a Hindu Minority and Guardianship Act doesn't talk of Canadian Hindus, British Hindus. So once you are a Hindu, you as a person, you are a Hindu, you may be, so your immigration, nationality and your resident status is immaterial. So her sister can adopt. And the child presumably would also be a Hindu, because she has been born to a Buddhist mother who would be classified as a Hindu. So this is the global Indian. And human relationships build out such complicated problems. But for a British judge to figure this out, now he sent me a supplementary question. Would Tibetan and Chinese law apply? I told him, well, the answer was Tibetan and Chinese law will apply to Tibetans or Chinese nationals living in Tibet or China, not Tibetans or Chinese domiciled in India or living in India for so many years. Law of domicile. So that's how problems come up. And every day, somebody somewhere poses such a problem which is beyond comprehension, and therefore global Indians. Now I'm going to go back to say, global law for Indians. That's the reverse title now.
Thank you, sir. Thanks to all the panelists for such an enlightening discussion. And I would like to congratulate Anil Malhotra, sir, and Ranjit Malhotra, sir, who's not here today joining us, on this fantastic book, which, though not in my area per se, I still want to read because it poses such interesting legal questions and gives an insight to problems which are actually happening every day. Like I have friends living in US and Canada, married under that law. And both of them are Indians, but they have been living there for so many years. And they do come back and ask such questions, what if, what not? So it's a good way to at least engage in a discussion in a friendly forum. Thank you, Murlidhar sir. Thank you, Narinder Singh sir. And thank you, Anil Malhotra sir. And thank you, Reshma ma'am, for this. Over to you, Lasya. Thank you, ma'am.
Thank you, Professor Shumanti, for moderating the session. And thank you to our esteemed panelists for expressing your thoughts and views on the questions that were posed. Now, to summarize the key takeaways of today's discussion and to deliver the concluding remarks, I would like to welcome Dr. Shashikala Gurpur.
Ma'am, you are on mute, please. Ma'am, please unmute yourself.
Ma'am, I thought you had gone for lunch.
We can't, that's not our job. I mean, just like how you do with the law courts, we do the same. I mean, I could still see Justice Murlidhar there and you thought he was gone. So we don't go until we finish the project. So it's a very symbolic question you have asked. It's an unfinished agenda. Means your book is an unfinished agenda, Anil.
And our US colleague has given us more food for thought.
Yeah, one is a US colleague, but from the beginning, Justice Murlidhar himself pointed out the areas which were wanting in the book, but which is a pressing problem. So you may develop a volume.
I have sent some material on it, a film and a PowerPoint, which you can circulate.
Yeah, we will. But maybe in the lines of what Ms. Reshma told, Attorney Reshma told, maybe you could develop the next volume, beginning with the highlights what Justice Murli presented.
Provided she co-authors the book.
Hope so. There could be, you could be the editor and there could be Malhotras could be the editors and there could be many authors, including Justice Murlidhar sir, hopefully. What I liked about this whole, what I would like to highlight as a key takeaway of this whole process of discussion is that the book became a window to explore the situation of global Indians and also to redefine the very understanding of global Indians. And Anil and Ranjit's justification of global Indians as Indians are everywhere, they are global, therefore we are discussing, that kind of a broad definition got more streamlined with the reflections that came in, and the underprivileged global Indians were highlighted in Justice Murlidhar's exposition. So also the way in which laws have been either used in ignorance or inadequately, or the way in which our embassy and our councils will have to be alert was highlighted by Narinder Singh sir. We also had a lot of learned exposition coming from Ms. Reshma, who has been working with such global Indians on the other side of the globe, in a relatively richer part, but relatively vulnerable population though. So it's a very interesting shades and contrasts which have been brought in from real life, the experiential nuggets. Now, coming to the connection to the book, which I would not lose focus on because today's key is the book. Now, 3 pain points alongside the genius that I recognize in the book, alongside the experiential nuggets which are brought in, because in some chapters he says, both of them say, after discussing the law, which is laid out in the beginning, the structure of the chapter is laid down or structure of the part is laid down, then the law is discussed, where it goes, as Attorney Reshma pointed out, almost like a handbook for a lawyer and a ready reckoner for related law. Then he concludes in a summary, and then they talk about our experience shows. I think this is the original insight in the book, which is very useful to the students as well as practitioners, and also to explore what was already pointed out as innovation, the judicial innovation that Dr. Murlidhar would have done as a justice, or Malhotras would have done in bringing resolution to the conflicts or situations of justice, or Mr. Narinder Singh would have brought as the expert and advisor to various ministries and at the international fora. Now, in all, as I told you, it's a most updated analysis, very balanced, very accurate, very crisp. It's like a compendium. So it's a scholar's envy and advocate's pride, because somebody who is an advocate writes in a way that scholars can envy. Somebody who is an advocate can be proud that an advocate can write such a book with such scholarly depth. However, there are three pain points individually I felt, one of which was identified by Justice Muralidhar and was in a way supporting from Mr. Narendra Singh's viewpoint, that is just a kind of gentle nudging on India adopting the Hague Convention on child abduction. I mean, there is a certain unhappy tone about the case-based outcome, and there is a kind of gentle pressure to get a policy in this place. But this is much to the chagrin and nightmare of the feminists who do not want this child abduction convention to be acceded to by India, because most of the time those who flee domestic violence flee with the child. However, I have gone through the deliberations and the report where Malhotra brothers argue for a more balanced solution in terms of exempting the idea of parental taking of the child out of the definition of abduction. Second is in part 23.17, there's a kind of assumption, a pro-Western bias, where the authors say that if foreign courts develop principles on anti-suit injunction, India may develop. So why do we assume that Indian judges follow suit? What about so many other jurisdictions which have been inspired by Indian judgments and have amended law, like South Africa or even Commonwealth jurisdictions? So I'm questioning this pro-Western bias. Third is the empathy for human rights violation foisted on diplomats and maid contracts and private invasion in case of Indian parents. Now, this empathy, in my opinion, is a little, it has to be taken with a pinch of salt, because it was already brought out by a couple of panelists that Indian diaspora, when they disperse, they also disperse their national social evils like caste system, untouchability, abuse of servants, hierarchical relationships, physical abuse of children. Considering that there is a hierarchical relationship between parents and children, the balancing of child's rights and child's dignity with it is not seen, which I mean, I was reading about how parents are the first with ignorance causing more mental trauma to children than any other agency in society can do. So Malhotra brothers, I'm in dire disagreement with this point as well. And then my argument is that be a Roman in Rome, like be a global Indian in the true sense, where you are adaptable and where you are open to the forces of change, which are positive, which have evolved out of very refined thinking, where the ideas tend to civilize you. So do civilize yourself. And then we have another point is, which is the best highlight in the book, the real justice in the virtual court. It's like Arundhati Roy's postscript in the award-winning novel, you know, God of Small Things. So this epilogue or the postscript is a very hopeful postscript, because it talks, or rather advocates, online dispute resolution, which I think is going to innovate this whole area of practice in a more efficient manner. And what I liked was a very, very literary command. I mean, of the book, make hay when sun shines. I mean, I think that's where the Victorian influence and that's where Minsky and Soli Sorabji come together when a book ends with that kind of a very beautiful aesthetic ending sentence. So overall, I think it has been a very rich discourse, enriched by each and every panelist through the nuggets of their experience, through their critical reflections, setting the future agenda for the authors. And in that is carried and hidden is the gem of great praise for the authors. Both the authors deserve great commendation, and all the panelists deserve our gratitude and commendation for rightly appreciating the book. Thank you, one and all.
Thank you.
And there is no lunch in the guest house or the faculty house today.
We missed that. Yeah.
I missed that.
Yeah.
Particularly in the luxury
I'm
suite.
really unfortunate not to entertain all the three panelists there. Yeah, but I think there is always a next time, and hope that is soon.
It is always happy to remember good memories.
Yes. Yeah.
And
And Samba restaurant
and the luxury and
dosa's.
hospitality which Symbiosis very kindly extends.
Thank you. Thank you. It's all our team. So
And you are a very effective leader of the team, devoted, dedicated 24/7, on call, all the time two academics, two students, as physically and virtually observed.
Thank you, sir. Thank you, ma'am, for succinctly summarizing the key takeaways of our discussion today and your critical analysis of the work, which is really the food for intellectual progress. So thank you very much for that. On behalf of Symbiosis Law School, Pune, I extend our heartfelt gratitude to our esteemed panelists, Honorable Justice Dr. S. Muralidhar, Advocate Anil Malhotra, Mr. Narinder Singh, and Ms. Reshma Sambari for your valuable insights and the voracious discussion that has taken place today. We thank our top management at Symbiosis International Deemed University for their constant support. And we are grateful to our visionary leader, Dr. Shashikala Gurpur, who drives this institute with her academic and administrative excellence. Thank you, ma'am. We are thankful to Oak Ridge Publishing for their support and extending a special offer of 40% off for Symbiosis students and attendees of the virtual book launch for the book, The Global Indians and the Law. We thank the organizers of the launch and panel discussion at Symbiosis Law School Pune's Career and Professional Development Cell and International Cell, who have meticulously planned the entire event and coordinated all aspects of it. I express my gratitude to our IT teams who work tirelessly to ensure that we can continue to host and organize events like this despite the physical restrictions. And last but not the least, I thank all the attendees, the students and faculty members who have made this event successful. Thank you all.
Thank
The
you.
participants may feel free to disconnect from the link now. Thank you for your attendance and your engagement.
Thank you.
Thank you all.
Thank you.
ma'am.
Thank you very much.
Thank you. Thank you.
Thank you.
Thank you, Judge Saab. Thank you, Narinder sir.
Thank you,
and Ms.
Professor.
Reshma, and
Thank you, ma'am.
most of all, Anil and the